Right, good evening. Welcome to the webinar on testamentary trusts, the fundamentals, what they are, and what you can do with them in your will and as part of your estate planning. So, for those of you who don't know me, my name is Jackie Broman. I'm the owner at TBA Law, and I am an accredited specialist in wills and estates. So what is that? Well, I'm a solicitor, so I did my law degree. I then went on and did a master's degree in applied law just in wills and estates. And then after that, I did a 12-month program with the Law Institute in Victoria with exams at the end, which gave me that special little logo that's on the screen. There are only about 80 of us out of about 20,000 solicitors in Victoria who have the Wills and Estates accreditation. There are accreditations in other areas of the law. So it is good if you can look for that little logo, particularly if you have some complexity. But as well as being a lawyer, and as you might see in my video tonight, coming to you in the evening, having been wearing a hat for the last hour walking the dogs. My dogs are my fur children. There's one of them down there, combination of two of my loves because the other is fishing. And that particular pup, he needs to be tied up on the boat because he loves the white water and he would be over the side in a flash if he wasn't. So that just gives you a little bit of context about who I am. Now, just a brief overview of what estate planning is in 2020, because life, I suppose, has gotten more and more complex over time. So many people say, my situation's simple, I just need a simple will. Yeah, in the 1950s, life was simple, but unfortunately, with most people, most situations aren't simple. And estate planning is not just a will anymore. So again, in the 1950s, we maybe had a house and a bank account. We didn't own much else, and we didn't have complexity around how we owned it. We didn't own things in trust. We didn't have investment properties. We didn't necessarily have share portfolios. They may have owned some shares in some partly owned government company or something like that. Tax laws have changed. They certainly didn't have superannuation back in the 1950s. And for many people these days, superannuation is one of our biggest assets. And there are, obviously superannuation is a special type of asset. So generally it's not covered by your will. There are only certain categories of people who you can give your super to. And if you give it to the wrong people, it can be taxed. We're obviously living longer these days as well. So that adds in more need for powers of attorney, advanced healthcare directives, either our body outlives our mind or vice versa. And aged care has become a necessity for a lot of people, and how that affects your estate planning, your entitlements to Centrelink, your structuring of your assets, and preparing for being cared for. So having said all that, let's get into what a testamentary trust is and what some of the benefits are. So before I launch into particularly a testamentary discretionary trust, let's just talk about a few types of trusts. So there are inter vivos trusts, are the kind of trusts that people set up while they're alive. So these are your family trusts, where people might run a business or might have some investment properties in a family trust. Or you might have a unit trust if you were in business with a partner who wasn't a family member. So there are various forms of trust that you might have while you're alive. Whereas a testamentary trust is any form of trust that is set up in your will. And that's why it's called testamentary. However, the general term testamentary trust is known by accountants and financial planners particularly as a testamentary discretionary trust. So the main forms of testamentary trust that we use commonly, the first one is called a minor's trust. So this is a testamentary trust that you set up if you're giving money to children who are under 18. It's a very, very simple trust. Funds are just held back until the child gets to whatever age you specify. So a minor's trust is a form of testamentary trust. A life interest is a form of testamentary trust. So this is where you give either a piece of property or it could be a portfolio of assets to someone for life for their use. And on their death, the trust ends and it goes to whomever you want it to go to. So those are two types of trusts. There are protective trusts, which the lump sum of inheritance gets held back and only whatever income it earns is paid to the beneficiary. So it protects the capital. This sort of trust might be used for someone who was a gambler or had substance abuse problems, because you don't want them to waste the capital, but you want them to have a regular income. A special disability trust is another sort of trust someone could look at, and that would be for a beneficiary who was on a disability pension, who you didn't want their inheritance to knock them off their pension, particularly because, you know, the NDIS has so many benefits now for those disabled people, but you still want to provide for them. And then the testamentary discretionary trust, which is really what we're talking about tonight. So again, when an accountant or a financial planner says, when you do your estate planning, I really want you to get advice on and consider having testamentary trusts in your will, this is the sort of trust that they're talking about, a testamentary discretionary trust. So we'll get into why you would have one soon, but a typical scenario might be, so husband and wife, ordinary family, no second marriage, nothing like that. So husband and wife together forever, 3 adult children, they leave everything to each other in their will, and then on the death of both of them, or the death of the second, they leave everything equally to their 3 adult children. But instead of leaving it to their adult children outright for them to get the funds in their own name, they decide to put it in a testamentary trust. And so then the 3 kids would get their inheritance in an investment vehicle, essentially. So they don't get it in their own name. They get it in a form that they still have access to, but there are particular benefits. So let's get into some of those benefits. So the first is asset protection. Now, one of the main reasons why parents consider a testamentary trust for their adult children is thinking about future spouses and separations. So they don't want their hard-earned life savings to go to their children only for it to become part of a property pool that is later split up due to separation. Or The adult children might be self-employed professionals. And so if they're working for themselves, their personal assets might be at risk if they were sued, if their business went bad. Same thing for tradies, builders, all those sorts of things. If a inheritance comes into your own name and you are personally liable for things under your business, the inheritance would be eaten into by creditors. So the testamentary trust provides a lot of protection for those scenarios. And the reason that happens is a number of things. So the bankruptcy court has some powers to set trusts aside, but it's more the family court jurisdiction that has a lot of discretion to set a family trust aside or look through the curtain or veil, so to speak, of a family trust and go, well, I'm going to ignore that this trust exists and just pull all these assets and inheritance into the property pool of the couple. Family court has that power, but we try and get around that with the drafting of our testamentary trusts. So firstly, a testamentary trust or a trust that can be looked through by a family court has usually one primary beneficiaries and very few other beneficiaries, if any. Secondly, if the trustee was the same person as the primary beneficiary of the trust, the court is more likely to look through the trust. And so we deal with both of these scenarios by firstly having broad categories of potential beneficiaries. None of the beneficiaries actually have a right to ask for the money, but they could. So they're there just for the court's benefit. And the other thing that we do is we say, okay, if the main beneficiary is also the trustee of the trust and they go through a separation or they have an insolvency event, they are automatically disqualified from being the trustee of the trust, in which case they would have to go to a sibling or their accountant or someone else, and they would say, I'm going through a separation, I need to have someone else as the trustee of my trust. And then there would be an independent person, essentially, who would be the trustee. And so by the time it gets to the court looks at it and goes, well, this is actually being managed by someone independent and there's multiple categories of beneficiaries. So no, we're not going to pull this into the property pool. So the relationship of the adult child and their spouse will have built up their own property pool together, which the court will look at to split if they're separating. If the child also has this testamentary trust over here, they've got this other financial resource. It's not getting pulled into this pool, but what will happen is that the child will likely to get far less of this pool, the percentage, because they already have a financial resource, all right? So that's the way that it works. It's not a good mathematical science in the family court. So if there was a property pool of 500,000 and the child had an inheritance of 200,000, maybe they'd only get 30% of the pool instead of 50%. So that's the sort of scenario that a testamentary trust helps with. The other thing that it can help with is an adult child beneficiary who just is not good with money. And so you would make sure that some of their other siblings or someone else was the trustee of their trust. And so they just weren't able to dip into it whenever they liked. So that there was some element of someone else helping them to manage their investments so that it made it worthwhile. And then you can also manage the flow through as well from your adult children down the bloodline or you know, you could specify how that sort of went. So a testamentary trust generally lasts for 80 years from when it's set up, not when the will is dated, from when you actually pass away, so it's triggered. So a testamentary trust often outlasts the initial beneficiary. So it is something that can benefit, you know, 3 or 4 generations potentially. Getting on to the next benefit, because it lasts so long and can help so many generations, there are significant tax benefits for that reason. So particularly in the 1980s and 1990s, family trusts were really popular with accountants because there were lots of tax benefits in them. Those tax benefits have all been scaled backwards. However, they haven't been on testamentary trusts. And so the government may work out that they've forgotten about this little loophole and tighten it up, particularly if the government wants to try and raise more funds. But at the moment, as we stand in 2020, there are significant tax benefits still for testamentary trusts. And those main benefits are through tax splitting out the income to multiple classes of beneficiaries. So in a family trust, accountants used to love setting them up because the parents would then have 3 children and the investment income would be pulled out into the kids' names. So it could be pulled out more tax-free money for the parents to use. That's all been scaled back. So now if a minor child gets funds from a trust, they can only get $450, or else they have penalty tax rates. However, in a testamentary trust, they still have those benefits. So the same example applies. 3 adult children, they each get their inheritance in a family trust. They each have children of their own. You know, they might be earning $80,000 to $100,000 of income themselves. So they don't want to be getting another $50,000 of income out of the trust because they'd be paying tax on that. However, if they have 2 children, for example, they can pull out $18,000 tax-free every year, which per child. So that would give them close to another $40,000 tax-free to use for the family. So it can be a significant tax benefit and a way that doesn't increase the tax rate of your children. If they inherited that money in their own name, the income that it earned year to year would just be part of their own taxable income. But in a trust, it wouldn't be. So there's another tricky little reason for having a testamentary trust. Now, what sort of inheritance or money would you need to have to bother looking at a testamentary trust? Well, I would say you would want at least $200,000 per trust. So if there were 3 children, you'd want the estate to be more than $600,000 for it to probably be worthwhile. What are the costs of the trust? So there's not much initial cost at all. It's basically just the cost of the will. Then when the trust is triggered, when you pass away, there's no extra cost at the time then to register the trust. All you have to do is get the probate and go and set up a trust bank account. And then it would get its own tax file number. And so on an annual basis, you would just be paying another tax return, and an accounting fee to do that tax return on the trust. So for the benefit of it, you would think that it would outweigh any ongoing cost, and the initial cost, the setup cost, like I said, is pretty minimal. So I am going to jump in and have a quick look at the questions. We're going pretty okay at the moment. Now, for those who are watching a replay, there is also a question function for you to use. That question that you submit will be emailed to me and I'll get back to you in 24 hours. So please utilize that function if you do have any questions from what I've talked about, because that is essentially the foundations of a testamentary trust, what it is, the different types. The main type that we refer to as a testamentary trust is a testamentary discretionary trust. And I've also talked about the asset protection benefits, particularly from the consideration of either insolvency or a separation of a beneficiary. And then we've just been talking about the tax benefits that you can get through having a testamentary trust. So coming back around again to what estate planning is in 2020, this little poker chip image is all the elements of the estate planning process that you get when you work with TBA law. So we look at your property and what you own and how you own it. We do the documents, obviously. So the wills, the enduring power of attorney, the medical power of attorney, the advanced healthcare directive. We make sure your binding nomination is set up on your superannuation properly. Now you can also see that testamentary trust is an element in there. Like I said, majority of people do end up with a minor's trust. We don't necessarily go into a lot of detail about how that works, just to say that yes, the funds are held back until, for example, your children get to 25. In the meantime, it can be used for their education and upbringing. We also look at any life insurance policies that you have, not necessarily so much the TPD, but definitely life insurance, because some of it can be paid direct to a beneficiary. So we want to make sure the nomination is accurate, or it can be paid into your estate, in which case we need to think about that topping up the assets in the will and what that impact would have. If there are minor children, we go through instructions to guardians. If you do have existing family trusts that are inter vivos, so set up while you're alive, we look at the powers in those to make sure that the control of that family trust ends up in the right hands so the right thing will happen. And then the last 2 points about your personal assets, we give a little bit of advice around that and whether there are particular gifts that you want to give and how to manage that process. And the same with memorial instructions, because these two elements I often encourage not to be in the will. The will often isn't looked at until after a funeral. So I talk about the process of making sure that the things that you want to happen actually happen. And then what is the process? So it takes 2 appointments. We try and keep those appointments only about 2 weeks apart. So once you start the process, it'll be over and done with in 2 weeks. When you make the first appointment, we send you out initial information, some things to collect your thoughts with. Not that you necessarily need to fill everything in and come along. We do need you to have thought about your family tree though, who the important people are, their full names and addresses. You come along, first appointment, we take as many instructions as we can so that we can start doing drafts for you. So in between the 2 appointments, we draft those documents, we email them to you. We go backwards and forwards a few times so that you understand. So we have all the information that we need and any tweaks so that by the time you come to your second appointment, they're all ready to go. They're printed. We present them to you. We have everything signed. We explain everything in plain English. And then after they're all signed, so you'll have valid documents done at the second appointment. After that, particularly if there's powers of attorney, we have to make sure that those are all signed. The acceptance forms are signed by the people you appoint. And then we then deliver to you a certified pack of all your documents. So that's the process. We would work out in the first appointment what sort of testamentary trust you might need. We would talk through some of the basic conditions around it, whether it was purely a straight testamentary discretionary trust just for the purposes of giving your children an investment vehicle as inheritance, or whether that we needed a little bit more tightening up. If there is a child who is a bit of a spendthrift, or needed, or potentially a child who had some substance abuse problems, we'd talk through, well, who needs to be in control of this? Do we need to limit the amount of income that can be paid to the child on an annual basis? Or what sort of discretion do we need to build in around it, and maybe pull back some of the controls that they would have for themselves. So we've got a lot of flexibility around how we deal with those elements. So we talk about all that at the first appointment, and then in the draft, and we go backwards and forwards a couple of times to make sure that you understood and we had those control elements right. So remember to use that chat box or submit a question if you have any. I will send the replay as well. So that is the package, that is the process. The result is that you have it done, it's finished. Your affairs are in order. You've got the inheritance to your kids protected. Your family's kept out of court, out of conflict, and you've saved your mental energy as well from having to think about it anymore. So the basic cost of doing the package with us for a couple is $1,100. You'd be looking at 3 times that cost if you did it with someone in the city. When you're setting up testamentary trusts, we do add an extra $500 onto our package. The testamentary trust is not a separate document, so it goes in your will. It adds an extra 10 pages to your will. And as I said, there's all those extra features that we change for whatever your needs are. But otherwise, I stuck to the half hour, guys. Thank you very much for sticking with me. I hope that gave you at least the fundamental understanding of what a testamentary trust is, the few types of testamentary trusts that you could use, that quite often when someone says a testamentary trust, they mean a testamentary discretionary trust, and therefore what the asset protection benefits and what the tax benefits are of having a testamentary trust for your beneficiaries. So let's answer some questions.